Good morning, everyone. I am attorney Nicole Huffman, and I am here today as a part of the Now With Nicole estate planning series. And today's topic is going to cover why single and married parents of minors need estate planning. During the month of October, Now With Nicole has been celebrating Family History Month. And as a part of Family History Month, we are trying to help people leave behind a positive legacy for their family. And a part of that is a financial legacy. And not just leaving them behind money, but also doing whatever it is that you can to the best of your ability so that there won't be any confusion or fights or more of a burden on your family financially because of something that you didn't plan for that you could have planned for. And I'm based here in Texas, so all the tips I'm providing today, they are based upon Texas law. However, generally anyone anywhere who has minor children may want to listen because these are some things I'm sure that are relevant to your case as well. And also, I have to give this disclaimer that this is not legal advice. I do not assume any kind of attorney-client relationship. If you would like more information about your estate planning, contact an attorney in your state and in your local jurisdiction for more information. Estate planning for people with minor children. In Texas, this can get a little tricky, and this is whether you are a single parent or if you're married. And I'm not even going to talk about in this video about blended families or when someone is married to someone who they may not be the parent of their child and that child was born outside the marriage, whether it was before the marriage or during the marriage. Those are all even more unique situations that can seriously affects estate planning in Texas. And this is why I encourage people to at least have the basic documents in place, which would be a will, power of attorney for if you become incapacitated, for your what happens to you medically. You give someone a medical power of attorney, an advance directive that's telling the physicians what do you want them to do if something were to happen to you. Say, for instance, possibly life-ending event happen. Do you want them to keep you on a ventilator? Do you want a DNR, do not resuscitate? What are the things you want to happen with you medically? A living will. Those are things that you want to have in place. And also for your finances, you would want a statutory durable power of attorney. If you become unable to manage your finances, you give someone else the power to manage them for you. And just because it says attorney or power of attorney, it doesn't mean it has to be an actual attorney. It just needs to be someone who you trust to do what it is that's in the document. And that may or may not be someone who's close to you. Because sometimes the people who are closest to us aren't willing to take on roles that we may want them to take on because they may not feel comfortable doing them, especially when you're talking about the advanced directives, the medical power of attorney, or the DNR, the do not resuscitate. People don't always want that responsibility. And some people are very sensitive to if something happens to you, they may not want to see the plug pulled or whatever. And you may not be able to trust them to carry out your wishes. Therefore, it's really important that you have something in writing and give people the power of attorney over you who you know will carry out your desires. And those are just some basic things that everyone needs. And when you get into the area of minor children, I do talk a lot about people having at least a will, but in all honesty, when it comes to minor children, you want to make sure that you do something beyond a will if you're trying to leave a legacy and protect that legacy after you're gone for your children. Because what happens in Texas is if you do have a will, you pass away, And if the other parent is still alive, whether you're or married or whatever, the other parent under Texas law automatically is going to get physical custody of the child unless their rights have been terminated. That's really about the only way they're not going to automatically get the rights. And then someone can come and protest and take it to court, and then it could be fought out in court. But typically Texas courts, they don't like to take children away from their parents when the rights haven't been terminated or the parent isn't found unfit. And where I see people run into problems, especially single parents, is they will appoint someone to have physical custody of their child once they're gone, but this person isn't their parent. They either don't know where the parent is, or maybe they do know where the parent is and they're just on the outs. Maybe they think the parent is a bum, or they don't like them, or whatever. And so they'll appoint someone else. That's not valid. You can't appoint someone who is not the parent if their right has not been terminated. Now, if you do that, what could happen is that you could there could end up in a situation where you'll now have the parent and this person or these people you appoint as a guardian, now they're fighting in court because you have said you wanted someone who's not the parent to be the guardian. And as much as I know people dislike to hear that the other parent is automatically going to be the guardian in Texas unless there's something that drastic that happens, but nevertheless, it's the law. And so when you're talking about leaving behind a positive legacy, one of the things that you don't want your children to remember about you is that you set up this situation whereby now people are fighting and grabbing for custody for whatever reason, but they might not even have a right to have custody if the other parent's rights have not been terminated or they're not found unfit. So that's something to really to consider. As hard of a pill I know that is for some people to swallow, that is the Texas law. And when you're looking at married couples, it's the same thing. Once you die, if you're married, you can't say I want my kids to go with my mom or my sister. You can't just do that unilaterally in your will. It's not That's not going to happen. If your spouse is still alive, if they're not found unfit, if their rights haven't been terminated or something, they're going to get custody of the children. So having known that, what may happen with the physical custody, one of the things that you should look at then is, what about the estate that you leave behind? And if you're single, this should be of concern, especially if you don't have a good relationship with the other parent, or even if you do have a good relationship with the other parent, but they're not fiscally responsible. You want to make sure to guard whatever estate it is that you have for your children. And one of the things that happens is if a person decides to leave property directly to a child, the courts in Texas are going to set up a court hearing so that a guardian can be chosen for who's going to be the custodian over the property, because children can't inherit property in Texas directly. So what you end up doing by just naming a guardian is that you've now created a situation where there has to be a court hearing. And this is the case with even if you're married. If you give property directly to your children, it's going to set up a situation where there is a guardian that you're going to have a guardian. If you do that in your will, you're going to have a guardian over that. And this is why I tell people that going beyond a will, you also need to look at considering doing a trust, whether you want to do a revocable trust, which is a living trust while you're alive, you still handle it, or an irrevocable trust, which is a trust that you no longer have control over. And those are a little more advanced topics that I'm going to be discussing in other sessions. But you're going to want to look at something beyond the will, because you want to try to avoid setting up a situation where the children's property, the estate of the child, is going to need a guardian over it, because that's when you're going to get the court involved, and they're going to appoint the guardian of the estate, and that may or may not be the person who you want. As a matter of fact, if you're married, or even if you're not married and you want the parent's child to be the guardian, that may or may not happen. Whether it's your husband or someone who's not your husband, or your wife or someone who's not your wife, that may not happen when you have to go to court, because courts can be a wild card. They like to they like to maintain things in the family as much as possible. But if a judge is going by what he thinks is in the best interest of a child, he or she may not allow the person who has physical custody, or the person who you want to be the guardian of the estate. One way to make sure that you get the person you want guarding the estate for the child is through doing a trust, through doing something like a life insurance trust, things like that, where you are able to put the property somewhere and then you appoint the trustee yourself. That way you're not having to deal with guardianship from the court if you're trying to leave something directly to your children. And some people, they try to get around this by leaving whatever it is they want to their children to the person who they want to have physical custody of their kids. And again, this may not be the best thing to do for your child and for his or her estate, because if you leave a gift directly to another person, even if you are thinking it will be to benefit the child, what happens when you die and they don't follow your wishes? They could be irresponsible. They could be a spendthrift. Even if they're not, life happens. What happens when a big bill is due and they don't know how they're going to pay it? And they now have this money or this property or whatever that you gave to them in your estate planning. Even though you did it for the children, it's theirs because you left it to them. So technically, they have the right to do whatever they want to with that property. And that's why you should be careful if you're trying to leave something to your kids, but the beneficiaries of it, or the person you choose to get the property in your will or whatever, they're going to be the ones who have the legal right to it. And how this happens is, for instance, if you have a car and you want your son to have it, but you leave it to the father and tell the father what you want the father to do with the car for the son, he can do that or he cannot. If it's in a will, he can choose not to do that. And so that's why, because it's his, he can do whatever he wants to with it. But if you left that car, for instance, in a trust, and if you had some kind of checks and balances in that trust about what the trustee can and cannot do, well, then you have just set up a situation where there's more of a safeguard for the child's property. But even in trust, there is a possibility, but it's a lot less likely for the trustee to decide, well, they have a need, but since they have a need, of course the child has a need, and they will go into the trust and they will get things out of it. And that's why it's important that you choose people who you trust to do the right things by your children. And one of the options you have is, on top of choosing one trustee, you can also choose a bank as a co-trustee, for instance, or some other kind of entity, or another person who has no interest at all to be a co-trustee with the person if you have some concerns about what's going to happen with the child's property. But if you do nothing but leave the property directly to someone else, or leave the property directly to the child and they're still a minor, well, you're setting up a whole bunch of other issues that may be avoided. The main one being a guardianship, and then they're having to go to court because they need to figure out who's going to be the guardian over this property that the children really can't have because they're minors. So you want to try to the best of your ability to avoid having to go to court for for your family, to avoid having to go to court, so that a guardian can be appointed over some property you left your children. And also, you don't want to leave the property directly to someone else, because it's legally theirs and they can do whatever they want to with it. So creating a trust, making sure you have people, a trustee who has the child's best interest in heart, and maybe even having co-trustees so that they can balance off each other. That's why it's important to look at those options as well, and go beyond just the simple will, because that may not be enough. And this is whether you are married or single. These are things that you should consider for your minor children, because even in married situations, you could love your spouse to death, but your spouse could be a spendthrift. Your spouse may be irresponsible with money. And if you want to make sure that your kids are protected, the what you leave behind is protected, may want to consider doing a trust for them and not having your spouse be the trustee. Or if your spouse is going to be the trustee, have another co-trustee or two other co-trustees, so that you can make sure that your spouse isn't just going to pilfer the inheritance. And it may not even be that they mean your children any harm, but when you're looking at someone who is not fiscally responsible, the chances of them suddenly becoming responsible after your death is not very high. So protect your children, to safeguard what you want to leave behind for them, considering doing a trust may be in your best interest. And I know I've heard a lot of discussion about whether a living trust is needed, or if a simple will is enough. And you should look at your family dynamics to decide whether you think a simple will is enough. But I would say, in my professional opinion, this is not my legal advice to you, but in my professional opinion, if you are a parent of minor children, a simple will is not going to be enough if you are really wanting to protect what it is that you have left for them. You're going to want to look beyond that. And as I said at the beginning, contact a lawyer in your state, in your local jurisdiction, to have them help you determine exactly what it is you may need for your family situation, because every situation is unique, and you should get some advice about yours in particular. And when it comes to estate planning, this is one of the areas where I do not advise on do-it-yourself products. There have been some times where I said someone could do something themselves. It may be easy to do some of the power of attorneys that I talked about at the beginning of the video, but in all honesty, if you're going beyond that into a will, into a trust, or anything like that, you're going to want to seek the counsel of an attorney, and not just do these do-it-yourself simple will kit things that you may find, because there may be nuances to your situation that those will kits won't cover. They may be great for someone who's a married adult couple with married kids, and they're just the perfect family, and there won't be any fights or issues. Well, the will kits are fine for that. If you live in a perfect euphoric world where nothing is going to happen once you die, so far as your property, they're perfect for that. Otherwise, if you live in a real world where there's so much potential for things to go completely left once you pass away, you're going to want to speak with an attorney about your estate planning. And again, these tips, they're not just for single parents of minors, but they're for all parents of minors. Please consider the things that I've said here today. And if you're in the Houston area, I am hosting a series of events about estate planning to help people get on the right track. And on November 1st, I am having a Women, Wills, and Wine, Ladies Night In. And if you're interested in information about that, you can find out more about it on my website at miriamnicolehuffman.com. That's MiriamNicoleHuffman. And look up the Law and Legacy Building series, and it'll talk about there about what we have going on so far as events dealing with estate planning. I thank you all for listening today. And if you want to link up with me on LinkedIn, you can find me at Miriam Nicole Huffman. Or if you want to tweet me or Facebook me, you can find me at username Now With Nicole. I thank you all for listening, and I hope you all have a fantastic day.